At the end of 2001, Argentina defaulted on its debts, and now in 2015, the world financial system and the world legal system is still living with its consequences. There have been some new developments. Anna Gelpern of the Peterson Institute for International Economics and Georgetown Law Center is here with me, Steve Wiseman, to explain the latest wrinkles. So, Anna, walk me through how this began.
So in 2001, around Christmas time, Argentina defaulted on roughly $80 billion plus in its foreign bonds, $80 billion worth of bonds. At the time, it was the biggest sovereign bond default in history. And it was in the middle of a giant crisis, and it took some years for the economy to stabilize, but ever since then, Argentina really has not had access to the international capital markets, at least not directly. But it was able to raise some foreign currency by selling domestic bonds to foreign investors. So these would be bonds issued and paid, at least in part in Argentina, and governed by the law of Argentina. But they would be ultimately sold to foreign investors, and they would be paid in US dollars, in euro, and other foreign currencies, right? So this was one way for Argentina to generate foreign exchange, even though it was cut off from the markets. In 2005 and 2010, Argentina restructured the debt on which it defaulted in 2001. And so some new bonds came out of that, the exchange bonds, the restructured bonds. But in that restructuring, roughly 8% of the bondholders sat out. They refused to participate.
They're called the holdouts.
They are called the holdouts, and many of them, though not all of them, have sued. Now,
and many of them, though not all of them, are speculators that Argentina calls vulture investors, or whatever.
Exactly.
Hedge funds, that sort of thing.
Exactly, right? So a lot of these folks are investors who bought at a very deep discount. They bought the debt for a fraction of the face value. That, in the view of some, qualifies them for all kinds of names. Others say they're just market participants, but they're also, pensioners. They're also just ordinary folks in the game. But the people who really matter, the people who have the resources and the wherewithal to bring the lawsuits about which we're going to be talking about, are those investors who bought cheap and who have the capacity to invest lots of money into these inventive legal strategies.
So they bought cheap, but now they're trying to get paid back at 100% on the dollar.
Not just 100% on the dollar, but also with very high past due interest, right? So the amounts they're seeking to recover are a multiple of the original principal, whereas the folks who restructured in 2005 and 2010 took a fraction of the original principal.
So let's fast forward. Last year, there was a court decision in New York that said what?
Well, beginning in about 2011, the judge in New York, who has presided over lots and lots of lawsuits against Argentina, pretty much lost patience. So he has ordered Argentina on many occasions to pay. He issued many, many judgments. And Argentina, being a sovereign state and effectively immune from having its assets seized. If you and I default on a mortgage, the house gets seized. If the sovereign government defaults on a mortgage, they don't really have much that can be seized outside their own borders. So in 2011, the judge got quite exasperated with the state of affairs and said, you know what, I am going to tell Argentina that under a clause in its old defaulted bonds, it is required to pay the holdouts, the defaulted bondholders, in full whenever it pays the restructured bonds their payment due, which could be just an interest payment, right? So as a result, a bunch of appeals followed, lots and lots of other litigation. Fast forward to June 2014, the Supreme Court refused to review this series of lower court decisions, and then Argentina faced a choice. Do I pay the holdouts in order to be able to pay my restructured debt, or do I stop paying everybody? Now, Argentina tried to keep paying the restructured debt, but because it cannot pay the creditors directly, it has to go through a series of foreign banks, right? The money that it tried to pay got stuck at Bank of New York Mellon. And so as a result, Argentina was not able to deliver the money to the bondholders, and it ended up defaulting on something like $28 billion worth of foreign currency, foreign law debt. Now, in the middle of it all, there was a subset of debt, $6 to $8 billion, that was in U.S. dollars, but governed by Argentine law, and that went through a series of Argentine institutions, then through an Argentine branch of Citibank, right? And then abroad to some foreign investors. Some of it stayed in Argentina and went to Argentine creditors, but some of it went to foreign investors through these different channels. And
so this category is what was affected by a decision earlier this month.
Exactly. So just last week, the judge essentially put an end to a series of exemptions it gave to Citibank, right? Where Citibank came and said, well, look, the debt that we're processing is not external indebtedness. It's not really external debt. It is not exchange bonds. It's paid through Argentine entities. Therefore, it really isn't covered by your injunction. Moreover, since Argentina, remember, has been issuing foreign currency domestic law debt for over a decade now, some of this debt that goes through Citi is mixed up with some of this new foreign currency domestic law debt. So Citi said, look, first of all, by the terms of your injunction, we should be excluded. And second of all, it's really impractical for you to include us because all kinds of stuff that really isn't within the purview of your orders gets caught up. Well, last week, the judge said, forget about it.
To Citibank, they lost.
Exactly.
So this has ramifications not only for Citibank, but any bank that deals with one of its branches in another country under domestic law of that country. In effect, the net of this mess in Argentina has been cast so widely that it's having ramifications for the international banking rules.
And this has been the risk. You're exactly right. This has been the risk all along. So the early warning sign was the fact that Bank of New York Mellon was caught up, was effectively the tool by which this injunction was implemented. And then a whole bunch of foreign entities were mentioned in the original injunction. So Euroclear, the European Clearing and Payment Institution, institutions in Luxembourg and the UK and in Belgium were all mentioned by name. But the thought was that so long as the debt that was being cleared, that was being paid through these institutions, was not New York law debt, and not English law debt, so long as it was somehow domestic in character, it wasn't affected. That goes away now.
So is this a case, I'm wondering, of globalization, which has elevated the importance of the New York-based U.S. financial system? The major banks in the U.S. are all based in New York, or mostly. Paying the price of their own success and paying the price of the important role of the US dollar in the global economy.
Absolutely, right. So here's what's happening. Countries have been able to, in a sense, have it both ways, right? Issue debt over which they have some control, domestic law, right? So they can do all kinds of things unilaterally, but sell this debt to foreign investors and have it go through international banks. Right? What you have now is sort of the realization of what this means, right? And the fact that governments that thought they had control actually don't, and that institutions that thought that they might get sympathy from a court in New York because they're torn between two sovereigns, right, get no sympathy whatsoever. So the judge essentially told Citibank, when Citibank said, you know what, we have an enormous presence in Argentina. We're being directly threatened with regulatory and criminal consequences in Argentina if we obey your orders. The judge's response was, you know what, I'm really sorry, but that's the price you're paying for serving Argentina.
Welcome to the global economy in 2015.
Exactly.
And the rules that have to apply.
So the judge effectively says, look, my goal is to force Argentina to the negotiating table, right? And I am going to use any means necessary at my disposal. So I am going to say anybody who has reason to care about their what courts in New York think of them, right, is now on notice not to help a country that I am trying to sanction.
Right.
Right. So anybody who is sort of carrying the money for Argentina, even if it's entirely outside the United States, if they have a presence in New York, if they have a presence in the United States, they're on notice. So, and as a result of the judge's orders, within 5 days of the judge's orders, Citibank announced that it's pulling out of the custody business in Argentina, right? So, facing the choice between following the orders of a New York court and incurring sanctions in Buenos Aires, they did exactly what the court was trying to get them to do, which is to say, you know, we're leaving Buenos Aires, at least in that line of business. Now, they have a huge banking network in Argentina. That still stays. But you know, that tells you that it's a sign of things to come, I guess, you know.
Well, that was complicated but fascinating. Thank you very much, Anna.